I want you to imagine a scenario for a second. Just picture this. You are sitting at your desk on a Tuesday morning.
Okay.
You run a small business or, maybe you're an independent contractor, and you are just hungry for new clients.
Right, a typical hustle.
Exactly. So you've got the spreadsheet open, right? And it's filled with a list of potential leads. You load that list into your brand new, totally state-of-the-art marketing software.
Software that probably promises you the world.
Oh, yeah. The moon and the stars. You draft this quick, friendly, pre-recorded voicemail, and then you hit a single button that just says, send to all.
Simple enough.
Right. But in that one fraction of a second, with that single click of your mouse, you instantly create a $3 million legal liability. One that could, frankly, completely bankrupt you.
It sounds like an exaggeration, right? Or maybe a hypothetical from some law school exam.
Yeah, totally.
But that exact scenario is a very real, incredibly pervasive modern reality.
Well, welcome to the deep dive. We have an absolutely massive stack of sources today.
We really do.
Yeah, we are pulling from dense legal briefings from the law firm Duane Morris, daily updates from the legal blog TCP World, and then also these hyper-local economic reports out of the South Bay of Los Angeles.
Plus some strategic roadmaps for commercial real estate developers. It's a wide net.
It is, but when you lay all these seemingly disconnected documents out on a table, they reveal this massive hidden war.
Yeah, a collision, really.
Exactly. It's a collision between the hyper-efficient tools of the modern digital economy, things like automated marketing, data scraping, algorithmic tracking.
Right.
And on the other side, there's this rapidly mutating web of privacy and labor laws that are just aggressively pushing back.
The tension here is just fascinating. Because, technology is constantly promising business owners that they can achieve infinite scale, right?
Yeah, just click a button and reach the world.
Right. Software tells you that you can reach 10,000 people instantly.
Yeah.
You can track a user's every click on your website and, optimize your delivery routes down to the microsecond.
But the law isn't always on board with that.
Exactly. The legal system is stepping in and asking these really fundamental questions about consent and privacy and worker rights in an age where the human element is basically being erased by automation.
Okay, let's unpack this by going back to that $3 million click of a button. Because I was reading through the Duane Morris briefings, and there is this federal court case from March of 2026 out of Nevada that genuinely made my jaw drop.
The Gaitan case.
Yes, Garvey v. Gaitan. The defendant, Brittany Gaitan, she's a real estate agent in Las Vegas, and she was just doing what thousands of real estate agents are taught to do at, seminars every single weekend.
Right, she went prospecting for leads.
Exactly.
I mean, the lifeblood of an independent real estate agent is lead generation. And one of the most common strategies in that entire industry is targeting what are called expired or withdrawn listings on the multiple listing service.
The MLS.
Right, the MLS. So these are homeowners who tried to sell their property, but the contract with their previous agent expired, or they just pulled it off the market.
So to a hungry agent, that is a prime target.
Yeah. Oh, absolutely. Yeah. That person clearly wanted to sell at some point.
Yeah.
So the logic is, you swoop in and convince them that you are the agent who can actually get the job done.
So Gaitan decides to go after these expired listings. And the sources mentioned she uses a third-party service, a data provider called Land Voice Data.
Right.
And their entire business model is basically scraping the internet and various databases to find the cell phone numbers associated with those expired MLS listings.
Yeah, they aggregate all that contact info.
So she builds this massive spreadsheet of homeowners. Then she uploads this list into a massively popular sales and marketing software platform called Go High Level.
And this is where we really see the danger of, democratizing enterprise-level technology.
Okay.
Go High Level is an incredibly powerful tool.
It does a lot, right?
Yeah. It allows a single person to build complex marketing funnels, trigger automated text messages, manage thousands of contacts. And in this instance, Gaitan used the software to execute something called a ringless voicemail drop, or an RVM.
I actually need you to break down the actual technology of a ringless voicemail for a second, because, it feels incredibly sneaky when it happens to you.
It really does feel invasive.
Right. You look down at your cell phone, you never heard it ring, there's no missed call notification, but suddenly you have a voicemail from a realtor pitching you. How does the software physically bypass the ringing of the phone?
Well, it's a very clever exploitation of how cellular networks operate. So when someone calls you normally, the call is routed through a switching center, right?
Okay.
And that center sends a signal to your physical phone to ring. If you don't answer, the switching center then reroutes the caller to a voicemail server.
Makes sense.
But ringless voicemail technology essentially creates a direct computer-to-computer connection with the carrier's voicemail server itself.
Oh, wow.
Yeah, it completely bypasses the switching center that triggers your device to ring. It just directly drops the audio payload right into your digital inbox. The software is specifically designed to avoid the human interaction entirely and just, leave the advertisement.
So over the course of 2 days in March 2023, Gaishan uses this bypass technology to drop pre-recorded voicemails into the inboxes of 983 unique cell phone numbers.
That's a huge volume.
Almost 1,000 people. And some of them she hit twice, which brings the total to 1,983 completed voicemails.
Which is exactly what triggers a catastrophic collision with the Telephone Consumer Protection Act.
The TCPA.
Universally known as the TCPA.
Yeah.
Congress passed this federal statute way back in 1991. The original intent, was to stop those annoying dinnertime telemarketers from blowing up your family's landline.
Right, I remember those.
But the law has been constantly reinterpreted to cover modern technology. Under the TCPA, it is strictly illegal to make any call using an artificial or pre-recorded voice to a cellular telephone number without the recipient's prior express consent.
And for marketing purposes, that consent generally must be written, right?
Exactly. It has to be written.
So one of the guys who received this phantom voicemail, Wayne Garvey, decides he is not just going to delete it. He hires a lawyer, files a lawsuit, and asks the federal judge to make it a class action representing all 983 people on that spreadsheet.
And the judge agreed.
Yes, the class was certified.
And the financial math of a TCPA class action, it's what keeps corporate lawyers awake at night, honestly.
Oh, I imagine.
The statute was intentionally written to be punitive. It allows for statutory damages of $500 per single violation. But, and here's the kicker, if the court finds that you willfully or knowingly violated the law, that penalty triples.
To $1,500 per call.
Per call, yes.
Let's run those numbers. 1,983 voicemails, multiplied by the maximum penalty of $1,500. That is a potential fine of nearly $2.97 million.
Just staggering.
For a single real estate agent working off her laptop over a 2-day period.
Yeah, and the defense team tried to dismantle the lawsuit using a few different arguments. And watching the court reject them is, I think, highly instructive for anyone running a business today.
But what was their first defense?
The first major defense is what the industry calls the MLS myth.
I have to admit, when I first read the brief, I was completely on the agent's side regarding this specific point.
Oh, really?
Yeah, I mean, think about it. If a homeowner voluntarily lists their house for sale on a public database like the MLS, aren't they putting their hand in the air and saying, please contact me, I want to do a real estate transaction?
That seems logical.
Like, if I put my phone number on a flyer to sell my used Honda Civic, I expect people to call me. Why is the law so rigid here?
It is a very intuitive assumption, but it entirely misunderstands the legal nature of the MLS and, more importantly, the specific requirements of the TCPA.
Okay, how so?
Well, the defense argued exactly what you just said. By placing their home on the MLS, these homeowners provided implicit consent to be contacted by real estate professionals.
Right.
But the federal judge tore that argument apart. The court noted that the MLS is a cooperative database designed to facilitate broker-to-broker cooperation, but only while a property is actively listed.
So once it expires.
Exactly. It is not a blanket, perpetual, irrevocable license for third-party agents to use automated software to spam those homeowners once the listing is expired.
That makes sense.
And beyond that, implied consent doesn't even matter here. The law requires prior express written consent for a pre-recorded telemarketing message. Gaitan had absolutely zero documentation that any of those 983 people specifically agreed to receive an automated voicemail from her.
Wow. So without the paper trail, you are completely defenseless.
Completely.
So the defense pivots to a much deeper philosophical argument. They try to challenge the lawsuit on constitutional grounds, specifically arguing about Article 3 standing.
Right, and standing is a foundational concept in the American legal system. Under Article 3 of the Constitution, federal courts are only allowed to hear actual cases and controversies.
They can't just hear hypotheticals.
Exactly. They cannot just offer advisory opinions or hear lawsuits from people who are merely annoyed. To have standing to sue, a plaintiff must prove they suffered an injury in fact.
And that has to be a real injury.
Yes. That injury must be concrete, particularized, and actual or imminent.
Okay, I see where the defense is going with this. They are saying to the judge, look at the technology. It's a ringless voicemail. The phone didn't ring. It didn't interrupt their dinner. We don't even know if these 983 people ever bothered to listen to the audio file.
Which is a fair point, technically.
Right. If they didn't listen to it, they weren't annoyed. If they weren't annoyed, they weren't injured. And if there is no injury, you have to throw this lawsuit out of federal court.
It is a highly sophisticated argument, and it has actually worked in other contexts, but it failed completely here.
Why did it fail?
The court ruled that under the TCPA, a call is legally considered a completed call, regardless of whether the phone rings or the person answers.
Even if it goes straight to voicemail.
Exactly. The judge ruled that the injury is not the psychological annoyance of listening to a sales pitch. The concrete injury is the unauthorized occupation of the consumer's digital property.
Ah, so the voicemail takes up space on a server.
Precisely. The voicemail consumes server capacity that is allocated to the consumer's paid cellular plan.
I see.
It forces the consumer to expend their own time to review the inbox, identify the unwanted message, and delete it just to reclaim that space. So the unauthorized delivery of the payload itself is the trespass. The intrusion is the injury.
Wow. So even if I hit delete without ever pressing play, the law recognizes that my digital space was violated the second that file arrived.
Yes.
And that violation is worth up to $1,500.
Which brings us to the broader ecosystem of liability here. Because Gatan was not operating entirely on her own. She was an independent contractor associated with Keller Williams.
Which is one of the largest real estate franchisers on the planet.
And the plaintiffs didn't just sue the agent, right? They went after the mothership.
They almost always do, right? Utilizing that concept called vicarious liability.
Exactly. The plaintiffs argue that this wasn't just a single rogue agent making a mistake. They allege that the massive franchisor provides the training, they encourage the aggressive lead generation, and they partner with the data scraping companies, like LandVoice Data.
So they're complicit.
That's the argument. Under the TCPA, plaintiffs can use a cause-to-be-placed theory of liability. If a corporation provides you with the automated dialers and instructs you on how to target expired listings, plaintiffs will argue that the corporation essentially caused those illegal calls to be made,
making them responsible for the millions in damages.
Right. And the sources actually note that Keller Williams recently settled a very similar TCPA class action for $40 million.
$40 million. I look at this dynamic and I think of an analogy. Giving an independent contractor access to something like go high level is like handing a 16-year-old the keys to a Formula One race car, but forgetting to teach them how the brake pedal works.
That's a brilliant way to put it.
I mean, the software is a Formula One engine. It is incredibly powerful. But the individual agent sitting at their kitchen table doesn't have a team of corporate lawyers sitting over their shoulders saying, hold on, let me review that spreadsheet.
Right. Nobody is asking, do you have express written consent updated within the last 15 days to account for numbers that might have been ported to a different carrier for every single person on that list?
Yeah, they don't have that oversight. They just see a button that promises to grow their business and they click it.
The technology has completely democratized mass communication. It's cheaper and faster than ever before. But it has absolutely not democratized legal compliance.
Not at all.
A solo entrepreneur using enterprise software is suddenly exposed to enterprise-level legal risk. And as the Nevada court showed, ignorance of the technicalities is not a defense.
Okay, let's unpack this a bit more, because this all seems very clear-cut, right? If you use automation to contact people, you absolutely must have prior express written consent, or you face ruinous fines.
That's the baseline assumption.
But just as I started to feel like I understood the rules of the road, the sources throw a massive wrench into the gears. Because when we zoom out from Nevada and look at the rest of the federal circuit courts, the legal map is completely fractured.
Oh, the landscape of consent is currently in a state of absolute chaos.
Chaos.
You have a judge in Nevada holding an agent strictly liable based on FCC rules, while other federal judges in different states are essentially rewriting how the TCPA is interpreted in real time.
I was reading about two specific cases that just shocked privacy advocates. Bradford v. Sovereign Pest Control out of the Fifth Circuit Court of Appeals, which, has jurisdiction over Texas, Louisiana, and Mississippi. And another case, Bradley v. dentalplans.com, out of a federal court in Maryland.
Yeah, those cases really turn things upside down.
Because in both of these instances, the courts completely abandoned the requirement for written consent. They ruled that giving your consent orally, just over the phone, is legally sufficient to receive pre-recorded telemarketing calls.
This is a seismic shift in the legal world. For years, the Federal Communications Commission, the FCC, which is the agency tasked with implementing the TCPA, has mandated a very strict rule.
It was written rule.
Right. Their regulation explicitly stated that businesses must obtain prior express written consent, with a signature, even an electronic one, before launching these automated campaigns. The FCC wanted a paper trail to prevent exactly these kinds of he said, she said disputes over whether someone actually agreed to be called.
So in the Fifth Circuit case, a man named Radley Bradford hires Sovereign Pest Control. And during the transaction, he verbally gives them his phone number.
Okay.
Sometime later, Sovereign Pest uses an automated system to call him with pre-recorded messages trying to get him to renew his service. Bradford sues.
Because there's no paper trail.
Right. He points to the FCC rule and says, "This is telemarketing and you do not have my signature on a piece of paper." He's asking for the standard penalties, $1,500 for each of the 24 calls, which is $36,000 just for his own claim, plus whatever the class action would generate. And the Fifth Circuit looks at the case and says, no, the oral consent you gave was enough.
The legal reasoning behind these decisions is rooted in a monumental shift in how courts view administrative agencies. Both the Fifth Circuit and the Maryland Court base their logic on a massive 2025 Supreme Court decision called McKesson.
McKesson.
Yes. The Supreme Court essentially ruled that federal judges no longer have to blindly defer to how alphabet agencies like the FCC interpret the laws passed by Congress.
Wow. So the Supreme Court basically told the lower court judges, stop asking the FCC what the law means and just read the text of the statute yourselves.
That is the core of it. And when these judges opened up the actual text of the Telephone Consumer Protection Act, the one that Congress voted on in 1991, they found that the statute only uses the phrase prior express consent.
And not written.
Exactly. The word written simply does not exist in the statute for these specific types of calls. The FCC added the written requirement years later through their own regulatory rulemaking process.
So the courts are concluding that the FCC overstepped its bounds.
Right. Congress never gave them the authority to rewrite the law and add new requirements that weren't in the original text.
It is a fierce application of the non-delegation doctrine, isn't it?
Absolutely. The idea that the legislative branch cannot just outsource its lawmaking power to unelected bureaucrats, because the actual law passed by Congress only demands express consent. The judges in Texas and Maryland determined that if a customer clearly gives their phone number to a business over the phone, verbally, that qualifies as express consent.
I understand the constitutional logic, but put yourself in the shoes of a chief marketing officer for a national brand. This creates an absolute nightmare scenario.
A total nightmare.
Let's say you are launching a massive nationwide automated campaign. Based on these new rulings, if you rely on oral consent, your campaign is perfectly legal and compliant for all your customers living in Texas, Louisiana, Mississippi, or Maryland. But if the exact same marketing software dials a customer who happens to live in Nevada or California, where the courts might still be enforcing the strict written requirement, you are suddenly violating federal law and facing a multi-million-dollar class action.
It creates a geographic minefield. A business cannot practically operate with 5 different definitions of what constitutes legal consent.
You just can't.
Compliance officers are basically forced to build their entire data architecture around the strictest possible interpretation of the law nationwide. Or, they have to geo-fence their marketing campaigns, which is technologically difficult given how often people move while keeping their old area codes.
Right. I have a friend who's lived in New York for 10 years and still has a Texas area code.
Exactly.
And the friction doesn't stop with outbound phone calls. A logical business owner might hear all this and think, okay, outbound marketing is legally terrifying. I'm going to stop calling and texting people.
A reasonable reaction.
Instead, I will rely purely on inbound marketing. I'll build a beautiful website, use standard analytics tools to track who visits, and serve them targeted digital ads. But the Duane Morris briefing showed that the plaintiff's lawyers are already waiting for them there, too.
Yeah, we are currently witnessing an absolute explosion of ad tech class actions. These lawsuits are terrifying for businesses because they target the invisible infrastructure of the internet itself.
We have 2 massive cases in the stack regarding this, Cole v. Quest Diagnostics and Golden v. NBC Universal. And these aren't about ringing cell phones, right? They are about the silent tracking pixels embedded in the code of almost every commercial website online.
Specifically, tools like Google Analytics and the Metapixel, which is Facebook's primary tracking software.
Right.
What is truly remarkable about these lawsuits is the legal mismatch. Plaintiffs are taking privacy statutes written in the 1960s, 70s, and 80s, laws written before the internet existed, and weaponizing them against modern web architecture.
Wow.
In the Cole case, the plaintiffs sued under the California Invasion of Privacy Act, known as CP, and the Confidentiality of Medical Information Act, or CMIA.
Let's break down that Cole case. Because Quest Diagnostics is a massive blood testing and medical lab company, and they had the Metapixel installed on their general public website, and they also had it installed on their secure, password-protected patient portal.
Right.
The plaintiffs argued that when a patient logged in to view their private test results, the Metapixel silently intercepted that data, specifically the web address, the URL, and the page title, and transmitted it back to Facebook's servers.
Yes.
So the lawsuit claimed that Facebook was operating as an illegal eavesdropper on their private, highly sensitive medical communications.
To really understand the ruling, we have to understand what the Metapixel actually does at a code level.
Okay, explain that.
It is a tiny piece of JavaScript code. When a user's web browser loads the Quest Diagnostics website, that JavaScript instructs the user's own browser to send a separate network request to Facebook servers, logging the interaction.
Let me test an analogy on you to see if I have the mechanics of this correct.
Go for it.
Imagine the Quest Diagnostics patient portal is a VIP room at a high-end nightclub. The website user is a guest trying to get inside.
Right.
The plaintiff's lawyers are arguing that the Metapixel is like a creepy private investigator hiding in the air vents of the club with a parabolic microphone, secretly wiretapping the conversation between the guest and the club owner, and then selling that recording.
That is the exact framing of the plaintiff's argument. They are attempting to classify the software as a surreptitious third-party interceptor under wiretapping laws.
But the Third Circuit Court of Appeals sided with the defense. They essentially said the Metapixel is not a guy hiding in the air vents. The Metapixel is the bouncer standing in plain sight at the front door.
Exactly.
When the guest's browser requests access to the site, the browser communicates directly with the Pixel software as part of the normal transaction to load the page.
Right, it's not a secret.
The court reasoned that you cannot be an eavesdropper on a conversation if you are a direct, intended recipient of that conversation. The user's browser is purposefully sending the information directly to Facebook's servers because the website's code told it to.
That is a critical legal distinction. The court held that as a direct recipient of the communication from the plaintiff's browsers, Facebook was a participant, not an eavesdropper. Therefore, there was no violation of the California Invasion of Privacy Act.
And what about the medical privacy claims?
The court dismissed those too, under the CMIA. The judges noted that the URLs being sent to Facebook only proved that a specific IP address was accessing a patient portal. The URLs did not contain substantive medical data.
So the Pixel wasn't transmitting the actual results of a cholesterol test or a cancer screening.
Exactly. And without transmitting actual medical information, the medical privacy law simply wasn't triggered.
Okay, I follow the logic there. But what about the second case, Golden v. NBC Universal? Because this one utilizes a completely different law, the Video Privacy Protection Act, or VPPA.
Yes, the VP.
The plaintiff in this case signed up for an NBC digital newsletter, watched some video clips on NBC's website, and alleged that her video watching history was secretly packaged and sent to Facebook via the Metapixel without her consent.
The history of the VPPA is actually pretty fascinating. Congress passed it in 1988 following a major political scandal.
Oh, really?
Yeah. During the Supreme Court confirmation hearings for Robert Bork, a journalist managed to obtain Bork's private video rental history from a local Blockbuster store and published it.
Oh, wow. I didn't know that.
Congress was outraged and quickly passed a law prohibiting the disclosure of personally identifiable information, or PII, tied to a consumer's video viewing habits.
And now, decades later, plaintiffs are arguing that streaming a video on NBC's website is legally identical to renting a VHS tape.
Right, and sending data to Facebook is identical to handing over a rental receipt.
So the question before the court was, did NBC illegally disclose her digital Blockbuster rentals to Mark Zuckerberg?
It's essentially yes. And the federal court in the Southern District of New York dismissed the case. Their reasoning hinges entirely on how we define personally identifiable information in the age of algorithmic encryption.
How did they define it?
The court ruled that for data to be considered PII, it must connect the consumer's identity to the specific video they watched. But crucially, the court held that it only counts as PII if an ordinary person could look at the data and identify the user.
Ah, this goes back to the code. Because the metapixel doesn't just send a plain text email to Facebook saying, Jane Smith just watched a clip of the Today Show.
Exactly. It sends a highly complex string of alphanumeric code, browser fingerprints, and encrypted cookie IDs. It's known as a hash.
Right.
If I printed out the raw data packet that the metapixel transmitted and handed it to you on a piece of paper, you, as an ordinary person, would have absolutely no idea what it meant. You couldn't identify Jane Smith, and you probably couldn't even identify the video.
You just see a wall of numbers and letters.
Exactly. It requires the massive, sophisticated, proprietary algorithmic power of a tech giant like Meta to decode that hash, cross-reference it with billions of other data points, and connect it back to a specific user's Facebook profile.
Because it requires a supercomputer and a proprietary algorithm to decode, it does not legally qualify as personally identifiable information under a standard written in the 1980s.
Yeah.
The court is basically saying if the average person on the street can't read the code, it's not a privacy violation.
And this ruling is a massive sigh of relief for the digital economy. I mean, if the court had decided that encrypted hashes were PII, essentially every media company, news outlet, and streaming service using basic web analytics could be subjected to class actions seeking billions of dollars in statutory damages.
But the privacy headaches for a business don't stop with tracking pixels. What happens when the data isn't being used for marketing but is actually stolen by malicious actors? Let's talk about the Dirty v. Bojangles case out of North Carolina.
Yeah, this brings us to the realm of data breaches. Bojangles, the massive fast food franchise, suffered a severe cyber attack.
Hackers penetrated their systems.
Right. They gained access to files containing the sensitive personal information of their employees. We're talking names, home addresses, and potentially social security numbers.
A group of former employees filed a class action. And honestly, their argument makes total sense on a human level. They're just basically saying, you were trusted with our most sensitive data, you failed to secure it, the hacker stole it, and now we are living in a state of constant anxiety.
It's a terrifying position to be in.
We have to spend our weekends monitoring our credit reports, looking for fraudulent loans, and we are suffering severe emotional distress worrying about our identities being sold on the dark web.
But once again, we collide with the constitutional requirement of Article 3 standing. You have to prove an actual concrete injury to maintain a lawsuit in federal court.
Wait, how is a hacker stealing your social security number not an injury?
Because of how the Supreme Court recently tightened the rules in a precedent called TransUnion v. Ramirez, the standard for what constitutes an injury in a data breach is now incredibly strict.
How strict?
The federal judge in the Bojangles case analyzed the plaintiff's claims and noted that fear of future identity theft, no matter how justified the anxiety might be, is fundamentally a speculative harm.
So anxiety isn't an injury.
Right. It falls into the category of this might be a huge problem tomorrow, rather than the required category of this is already a concrete problem today.
So unless you can walk into court with a credit card bill showing that a hacker actually used your specific social security number to buy a flat-screen TV, you haven't been injured yet.
Exactly.
Just knowing the hackers have your data sitting in a folder on their computer isn't enough to let you sue the company that lost it.
That is the current reality of federal data breach litigation. The court dismissed the case. There was actually one plaintiff in the lawsuit who did have unauthorized fraudulent charges appear on his debit card after the breach.
Oh, really? What happened with him?
The judge dismissed his claim as well, based on the concept of traceability. The plaintiff could not definitively prove that he had ever provided that specific debit card number to Bojangles during his employment.
Oh, wow.
And if he never gave the card to Bojangles, the hackers couldn't have stolen it from Bojangles' servers. Therefore, the fraud he suffered wasn't legally traceable to the company's security failure.
Okay, I want to pause and synthesize this environment because if I am a listener trying to operate a business right now, I am feeling completely paralyzed. Let's look at the option.
That's grim.
If I use outbound marketing calling and texting leads with automation, I am navigating a legal minefield that could cost me millions of dollars, like in Nevada. And I can't even rely on clear rules because federal courts disagree on whether I need written consent or if a phone call is enough.
Right.
If I switch to inbound marketing and use standard tracking pixels on my website to see what my customers want, I am almost guaranteed to get hit with a class action under wiretapping laws.
Yes, the EdTech lawsuits.
I will probably have to spend hundreds of thousands of dollars on defense lawyers just to convince a judge that the code is too complex to count as an eavesdropper. And then, if my servers get hacked, I might dodge a lawsuit, but only because the Supreme Court requires my employees to actually suffer identity theft before they can sue me.
It is an operating environment defined by extreme legal friction immense cost, and massive unpredictability. Which naturally forces the market to ask, how on earth do businesses safely acquire clients and grow in this climate?
And that question leads us directly into our next stack of sources, which focuses on the macroeconomic and strategic shift. Because capital and innovation don't just throw their hands up and quit, right? They adapt.
They always do.
The sources provide an incredibly detailed microeconomic case study on exactly how savvy operators are pivoting away from digital liability and back to physical high-trust authority. We are looking at a massive movement of capital into the South Bay of Los Angeles cities like San Pedro, Torrance, and El Segundo.
The data coming out of the South Bay is a perfect illustration of how macroeconomic policies and the legal friction we just discussed force entire industries to fundamentally change their behavior.
We need to start by understanding the phenomenon of capital flight. In April 2023, the city of Los Angeles enacted a new policy called Measure ULA. In the press, it was widely referred to as the mansion tax, but the reality is that it applies to almost all real estate transfers, including commercial and industrial properties.
Right.
It imposes a 4% to 5.5% transfer tax on any property sold for over $5 million within the city limits. Now, the sources provide this data without taking a political stance, and we won't either, but the numbers are wild.
It is important to look at this purely through the lens of objective economic data, setting aside the political debates surrounding the tax. The implementation of Measure ULA created an immediate and dramatic chilling effect on development within the boundaries of Los Angeles.
Just a freeze.
The reports indicate a staggering 40% drop in overall building permits.
A 40% freeze in construction is massive. But that investment capital, those developers and those businesses, didn't just evaporate.
No, they didn't.
They simply looked at a map and moved a few miles south, just across the city border, into the independent municipalities of the South Bay that are not subject to the ULA tax.
The sheer volume of this capital flight is reshaping the region. Areas like Torrance, El Segundo, and Gardena are absorbing all this overflow investment. As a result, industrial vacancy rates in the South Bay have plummeted to a very tight 4.6%.
Wow.
And in highly desirable markets like El Segundo, the vacancy rate is an incredibly competitive 3.4%. There's practically no empty space left.
And the companies taking up this space are not just your standard logistics warehouses storing cardboard boxes. We are seeing a massive hard tech boom. There is one detail in the sources that I found absolutely fascinating.
Which one?
It highlights a company called Varda Space Industries. They just leased a 200,000 square foot facility in El Segundo, and the history of this specific building is incredible. Do you know what it used to be?
It was a former manufacturing plant for Mattel.
Yes. It was a toy factory. They used to injection mold pink plastic for Barbie dolls in this building, and now Varda Space Industries is taking over this massive footprint to manufacture pharmaceuticals.
But they aren't just making normal drugs.
No. They are manufacturing a specific pharmaceutical called ritonavir, specifically Form 3, and the twist is they are building the orbital reentry capsules to manufacture this drug in space, in microgravity.
It sounds like a premise from a science fiction novel, doesn't it?
Totally.
But it is driven by pure physics and high-end economics. Certain highly complex protein crystallizations and drug formulations are incredibly unstable or even impossible to create perfectly under the constant stress of Earth's gravity.
Right.
By launching the raw materials into orbit, manufacturing the crystals in a microgravity environment, and returning them safely to Earth, these companies can create perfectly stable, highly lucrative pharmaceuticals that are fundamentally superior to anything made on the ground.
So you literally have a piece of real estate transitioning from making plastic toys to engineering orbital pharmaceutical laboratories. That is the reality of the South Bay right now. It is hyper-competitive, high stakes, billions of dollars on the line, hard tech real estate.
And we are seeing massive infrastructure capital following this tech boom. The reports detail a $10.9 billion merger between Fifth Third Bank and Comerica, with the explicit strategic goal of targeting this rapidly expanding South Bay middle market.
It's like a gold rush.
You also have the 42-acre West Harbor development project in San Pedro, which is transforming the waterfront with a 6,200-seat open-air amphitheater right inside an active industrial port. The Harbor Department is even issuing RFPs, requests for proposals for companies to design synchronized waterfront drone shows to entertain the influx of capital.
Okay, I'm tracking the development, but I need to connect the dots back to our previous discussion.
Yeah.
We have massive capital fleeing Los Angeles into the South Bay. We have space drug factories, multi-billion-dollar banking mergers, and waterfront amphitheaters.
Right.
What does any of this have to do with the TCPA lawsuits and the metapixel trackers that are terrorizing the digital economy?
It has everything to do with how you close a deal. Because the commercial real estate brokers trying to lease that incredibly scarce 3.4% vacancy space and the banks trying to secure the financing for an aerospace company cannot rely on the old digital marketing playbook.
They just can't.
The stakes are too high and the target audience is too sophisticated.
You can't just buy a scraped database of aerospace executives, load it into Go High Level, and hit them with a ringless voicemail drop. Brittany Guyton tried that with residential real estate, and she is facing a $3 million lawsuit.
Exactly. The legal risk is ruinous. But beyond that, the tactic is fundamentally ineffective at this level. You cannot spam the VP of operations for a company building orbital satellites. They will block your number and delete your emails.
Yeah, they're busy.
The strategic pivot, which is brilliantly analyzed in the sources by a company called Voxel Micro Video Labs, is a complete shift away from outbound digital spam toward what they call inbound visual authority.
I want to spend some time on this because Voxel's 2026 media roadmap outlines a fascinating psychological shift in how business is done. If cold calling is a legal liability and nobody reads text-based PDF brochures anymore, what is inbound visual authority?
Savvy operators realize that to attract high-end, sophisticated clients safely, they have to build their own high-fidelity media ecosystems.
What does that look like?
Specifically, they're turning to high-end video podcasting. They're abandoning the cold outreach model and instead inviting the decision makers directly into a physical studio to have a recorded conversation.
The roadmap calls this a Trojan horse networking strategy, and I love the psychology behind it. Think about it. Let's say I'm a commercial real estate developer in El Segundo, and I desperately want to lease a new building to a rapidly growing aerospace startup. I could call their CEO and beg for a 15-minute coffee meeting to pitch my building. The CEO is busy. They will ignore me. But what if, instead, I invite that CEO to be a featured guest on my professionally produced 4K video podcast to discuss their expertise on the future of hard tech logistics in the South Bay?
The psychology completely flips. They say yes, because you are no longer a salesperson begging for their time. You are a media host offering them a prestigious platform to elevate their own brand.
Exactly.
You get the ultimate decision maker in a room with you for an hour. You build genuine high-trust human rapport. You establish your own authority by guiding the conversation. And you bridge the gap between your physical real estate expertise and your digital presence.
All while avoiding the legal trap.
Yes. You achieve all of this without risking a single TCPA violation or needing a tracking pixel.
I understand the strategy, and it sounds great on paper, but I have to push back hard here. I run a podcast. I mean, we do these deep dives all the time. I know the agonizing amount of work that goes into this. Setting up a studio, tuning the lighting, syncing the audio, color grading the footage, cutting out all the ums and ahs, and then trying to figure out how to format clips for LinkedIn, YouTube, and TikTok.
It's a massive job.
It takes days of labor. Isn't telling a busy commercial broker, hey, just start a podcast to get leads, putting them on a completely unrealistic hamster wheel. A commercial broker needs to be touring properties and negotiating leases, not sitting in Adobe Premiere editing TikToks. Who has 40 hours a week for this?
That is the exact point of friction that Voxel Micro Video Labs aims to eliminate with their physical infrastructure in San Pedro. They recognize that business owners want the authority of media, but cannot afford the time sink of production.
So what's their solution?
Voxel provides a turnkey, walk-in, walk-out studio environment. The business owner literally never touches a camera or an editing timeline. But the true innovation is their distribution efficiency model. They have engineered a system that requires only 12 hours of the founder's time per year.
Hold on. 12 hours a year. How can you possibly generate enough digital content to stay relevant with only 1 hour of recording a month?
It requires abandoning traditional production methods and utilizing what they call the vertical slice technique to combat format fatigue.
Format fatigue.
Yeah. Format fatigue is the exhaustion creators feel when they try to film a wide-angle, horizontal video for a platform like YouTube, and then feel compelled to film the exact same content again, holding their phone vertically, to make an Instagram reel or a TikTok. It doubles the required effort for diminishing returns.
So how does the vertical slice solve that?
You film the conversation exactly once, framing it horizontally, but using ultra-high-resolution 4K or even 6K cinema cameras. Because the resolution of the image is so massively dense, the post-production editors can simply take that horizontal video and crop out the center vertical slice of the image for mobile platforms.
Oh, that's smart.
The original framing is designed to work for both dimensions simultaneously. Because the source footage is 4K, zooming into that vertical slice doesn't degrade the visual quality at all. You look crisp, professional, and expensive on a mobile phone screen without ever having to repeat yourself or film a second take.
I see. So you sit down in the chair for 1 hour a month. You record a deep dive, highly authoritative conversation with an aerospace executive. You walk out. The production team takes that 1 hour footage, uses the vertical slice technique, and chops it up into 30 high-quality, short-form vertical clips. You now have premium daily content for an entire month from just 1 hour of work. You establish absolute authority in your market, and you draw those multi-million-dollar clients to you rather than illegally spamming them. It's brilliant.
It is the ultimate market adaptation to the severe legal constraints we discussed in the first half of the deep dive. You replace the cheap, legally toxic automation of voicemails and tracking pixels with high-quality, transparent, inbound human connection.
Before we move away from the South Bay, there is one more massive dynamic at play in the region that the sources highlight. The entire area is currently prepping for an influx of international capital related to two global mega events: the 2026 FIFA World Cup and the 2028 Los Angeles Olympics.
Right, massive events.
How are these events impacting the long-term planning of blue-collar industrial towns like San Pedro?
It creates what is arguably the greatest challenge in modern urban planning. Planners refer to it as the white elephant syndrome.
A white elephant. Something that costs an absolute fortune to build and maintain, but serves no real practical purpose once the initial party is over.
Precisely. Look at the West Harbor project we mentioned earlier. They are building a 6,200-seat amphitheater and 300,000 square feet of high-end retail right inside an active working-class industrial port.
It's quite the contrast.
They are engineering the waterfront to handle millions of international tourists for the Olympics. But the critical existential question for the city is, what happens to the DNA of the community on a random Tuesday in 2029, long after the tourists have gone home?
Right.
Will this massive infrastructure actually serve the local residents, or will it permanently fracture the neighborhood's working-class soul, leaving behind massive, empty, hyper-expensive facilities that the local economy simply cannot support?
It is a terrifying high-wire act for the developers. They have to balance the unrelenting logistical demands of a global freight port with the aesthetics of premium luxury tourism, while trying not to completely destroy the historic fabric of the town that made it appealing in the first place.
And if you are a local business owner trying to survive and navigate that extreme level of local change, relying on a digital algorithm or a scraped lead list to save you is entirely insufficient.
They just won't cut it.
You have to establish your own unshakable voice and authority in the community, which loops right back to the necessity of the high-trust media strategy we just discussed.
Okay, we have covered a tremendous amount of ground. We have explored the legal nightmares of automated marketing. We have waded through the privacy battles over how businesses track consumers online. And we've seen how smart capital is pivoting its physical real estate and digital media strategies to attract clients safely.
It's a lot.
But there is a whole other side to this equation that we haven't touched yet. Because a business isn't just about how it interacts with the outside world.
That is correct.
Yeah.
The friction of the modern digital economy is not just an external problem dealing with marketing and clients. The drive for hyper-efficiency is fundamentally altering internal operations, logistics, and labor laws.
You can build a state-of-the-art video podcast studio in El Segundo to attract the perfect aerospace tenant. But if your internal logistics are legally flawed or your labor classifications are wrong, the resulting class action lawsuits will bankrupt you before the tenant ever signs a lease.
Absolutely.
Let's look at a major case heading to the Supreme Court in October 2025. Brock v. Flower Foods.
This case cuts straight to the heart of the modern gig economy and forces the Supreme Court to define what interstate commerce actually means in an era of hyper-optimized supply chains.
What's the background?
Flower Foods is a massive national bakery corporation. To distribute their products, they rely on independent distributors, essentially gig economy delivery drivers, to transport their baked goods from local regional warehouses to the final retail grocery stores.
The plaintiff in this case is a guy named Angelo Brock. He signs a standard contract to be one of these delivery drivers, and like almost every independent contractor agreement written in the last 10 years, his contract contains a mandatory arbitration clause.
Very standard.
This clause says that if Brock ever has a legal dispute with Flower Foods, he waives his right to sue them in a public court of law, and he definitely waives his right to form a class action. He must take his grievance to a private individual arbitration process.
Companies heavily favor arbitration because it is generally faster, quieter, and prevents the catastrophic financial exposure of a massive class action. But Brock decides to file a federal class action anyway.
On what grounds?
He claims that he and thousands of other drivers were illegally misclassified as independent contractors under the Fair Labor Standards Act, the FLSA. He argues they are actually employees, and therefore they are legally entitled to minimum wage protections, overtime pay, and benefits.
I can imagine the response from Flower Foods. They point to the contract and say, "Hold on. You signed an arbitration agreement. We aren't arguing about whether you are an employee right now. We are saying you aren't even allowed to be in this courtroom. Case dismissed, go to private arbitration."
Exactly. That's their play.
But Brock's lawyers pull out a fascinating trump card hidden in a different law, the Federal Arbitration Act or the FAA.
The Federal Arbitration Act is the law that makes these corporate arbitration clauses enforceable. However, the FAA contains a very specific historical exemption. It explicitly states that transportation workers engaged in interstate commerce are exempt from forced arbitration.
Like railroad workers.
Exactly. The original intent was to protect railroad workers and merchant marines. If you fall under this exemption, the arbitration clause in your contract is void, and you are allowed to sue your employer in open court.
And this creates a massive legal knot for the Supreme Court to untangle, because Angelo Brock's delivery route was entirely within the state of Colorado. He picked up the bread in Colorado, and he delivered it to stores in Colorado. He never once drove his truck across a state line.
Not once.
So Flower Foods argues, you are a local interstate driver. You do not cross borders, therefore you are not engaged in interstate commerce, and the exemption does not apply to you.
But Brock counters with a very modern interpretation of logistics. He argues, the physical bread that I am delivering inside Colorado was actually baked in a factory in another state. Flower Foods shipped that bread across multiple state lines to get it to the local Colorado warehouse where I picked it up.
Right.
Therefore, even though I never leave the state, my local delivery route is the final essential link in a continuous interstate chain of commerce.
And the 10th Circuit Court of Appeals actually agreed with Brock. They ruled that a transportation worker does not need to physically drive across a state border to qualify for the exemption. If their local route plays a direct and necessary role in the continuous flow of goods from one state to another, what the logistics industry calls last-mile delivery, then they are considered interstate workers and cannot be forced into arbitration.
It's a huge ruling.
Why is the Supreme Court getting involved in whether a guy delivering bread in Denver is an interstate worker? Let me try an analogy to explain the friction here. Think of the flow of goods like an Olympic relay race. You have 4 runners passing a baton. The first 3 runners carry that baton across multiple state lines. The 4th runner, the anchor leg, receives the baton just inside the Colorado border and runs it the final mile to the finish line, never leaving the state. The legal question is, does that anchor leg get credit for running an interstate marathon, or are they just running a local sprint?
That analogy perfectly encapsulates the question before the Supreme Court, and the macroeconomic implications of their decision are staggering. Think beyond baked goods.
Right, Amazon.
Think about Amazon delivery drivers, Uber Eats couriers, FedEx contractors, and the entire army of local gig workers who power the modern economy. Almost all of the goods they deliver originated in another state or another country. If the Supreme Court upholds the 10th Circuit's ruling, millions of last-mile gig workers could potentially invalidate the forced arbitration agreements in their contracts.
Which means the floodgates open. They can band together, form massive class action lawsuits, and sue the biggest logistics companies in the world for billions of dollars in minimum wage and overtime violations. It would radically alter the baseline labor costs of the entire gig economy.
And speaking of those massive wage and hour class actions, there is another fierce legal battle happening right now over the actual rules of how those lawsuits are fought. The sources highlight a deepening, chaotic circuit split regarding the Fair Labor Standards Act.
FLSA cases again?
Yes. The Supreme Court is currently facing urgent petitions in cases like Richards v. Eli Lilly and Harrington v. Cracker Barrel, begging them to restore order.
We talked about circuit splits earlier when we discussed the TCPA phone calls. It means different federal appeals courts are applying entirely different rules to the exact same federal law. What is the split regarding labor law?
It is a battle over legal procedure, specifically regarding how a judge decides to certify a collective action. Let's imagine a scenario. One single employee sues a national restaurant chain, claiming they were forced to work off the clock and weren't paid overtime.
Okay.
That one employee wants to transform their single lawsuit into a massive collective action by notifying thousands of other employees across the country and inviting them to join the lawsuit against the company. The critical legal question is, how much evidence does that first employee need to show the judge before the judge authorizes them to send out those thousands of legal notices?
It sounds like a minor, boring procedural debate, but the sources make it clear that this specific question dictates whether a company settles for millions or fights the case. Why is the notice so powerful?
Because the process dictates the leverage. Currently, there are 5 different approaches being used across the various federal circuits. The traditional approach, which has been used for decades, is called the Lusardi standard. Yes, it is a very lenient 2-step process. In the first step, the plaintiff only has to make basic, generalized allegations that everyone in the company was treated the same way. Crucially, at this early stage, the judge does not look at any counter evidence from the employer.
So it is incredibly easy for the plaintiff to win step 1.
It is practically a rubber stamp. Under the Lusardi standard, district courts grant conditional certification and order the notices to be sent out an astonishing 84% of the time.
Wow, 84%.
Once those official court notices go out to thousands of employees, the pressure on the company becomes immense. Even if the company knows the underlying claims are weak, the sheer cost of conducting legal discovery, interviewing thousands of employees, pulling millions of emails, forces them to settle. Statistically, only about 10% of these cases ever survive to the second step of the process, where the judge actually looks at the evidence rigorously.
An 84% success rate at the first hurdle is a plaintiff lawyer's absolute dream. But you mentioned there's a split. So not all courts are using this lenient Lusardi standard anymore.
Correct. The corporate defense bar fought back, and the Fifth Circuit Court of Appeals agreed with them, creating a strict one-step process known as the Swales standard.
Swales.
The Fifth Circuit completely rejected Lusardi. They ruled that it is unfair to force companies into massive settlements based on mere allegations. Under Swales, the district court must rigorously examine all the available evidence from both sides right at the very beginning, before any notices are ever sent to other employees.
That's a huge shift.
And other circuits have created even more variations. The Sixth Circuit created the Clark standard, requiring a plaintiff to show a strong likelihood of similarity. The Seventh Circuit, in the Richards case, adopted a middle ground that requires a showing of a material factual dispute.
So we literally have 5 different rule books for how to run a national wage lawsuit. Massive companies like Cracker Barrel and Eli Lilly are begging the Supreme Court to step in and pick one single standard for the entire country, because trying to manage national HR policies when the legal exposure changes dramatically every time an employee crosses a state border is completely unsustainable.
And while employers anxiously wait for the Supreme Court to sort out that procedural chaos, we are seeing some powerful protective trends emerging for companies in other jurisdictions. Let's examine a case called Schamberg v. Ives Pizza.
This is a case out of a federal court in Virginia involving a franchisee of Pizza Hut. A group of pizza delivery drivers sued the franchisee. Their core argument was that they were required to use their own personal vehicles to deliver pizzas, and they had to pay for their own gas, car insurance, maintenance, and cell phone data out of their own pockets.
Standard delivery driver claims.
Right. They claimed that when you subtract all those necessary business expenses from their paychecks, their actual take-home pay fell below the federal minimum wage.
The underlying wage claim is common, but the plaintiff's legal strategy was extremely aggressive. The plaintiffs were not just drivers from Virginia. The lawyers tried to construct a sprawling nationwide collective action, bringing in delivery drivers from multiple different states.
Yeah, they filed 17 different state law claims representing 7 different states, all inside a single Virginia courtroom.
It's what lawyers call a kitchen sink lawsuit. Throw every possible claim from every possible state at the wall and see what sticks. But the federal judge in Virginia sliced away almost the entire lawsuit.
Why did they do that?
The judge dismantled the case using the doctrine of personal jurisdiction. The franchisee, Ives Pizza, does not have its corporate headquarters in Virginia, nor is it legally incorporated in Virginia. They simply operate some franchise locations there.
Okay.
The court ruled that under the Due Process Clause of the Constitution, out-of-state plaintiffs cannot drag a corporation into a Virginia court to sue them for actions that occurred in entirely different states.
They applied a major Supreme Court precedent called Bristol-Myers Squibb.
Exactly. The Bristol-Myers precedent requires specific personal jurisdiction for each and every plaintiff in a mass lawsuit. The Virginia court's ruling is a direct crackdown on the practice of forum shopping. Forum shopping is when plaintiffs' lawyers scour the country looking for a specific judge or a specific court circuit that has a history of being friendly to labor claims, and then they try to file their massive national lawsuit in that friendly court, even if the out-of-state workers have absolutely zero connection to that state.
I see.
The judge dismissed all the out-of-state claims, leaving only the claims of the local Virginia drivers. It is a massive defensive weapon for employers to fracture and break up these sprawling multi-state mega lawsuits.
So the iVaz Pizza case is a significant victory for employers trying to limit the geographic scope of a lawsuit. But then we look at a case like Johnson v. Amazon, and we see a massive victory for employees regarding what specific activities count as paid work time. This case comes out of the Illinois Supreme Court in 2026.
The facts of this case take us back to the height of the COVID-19 pandemic. Amazon required its warehouse employees in Illinois to undergo mandatory health and symptom screenings before they were allowed to enter the warehouse floor and clock in for their shifts.
Standard protocol at the time?
The employees filed a lawsuit alleging that waiting in line for these screenings took an average of 10 to 15 minutes every single day, and they were not paid for that time.
Wait, I feel like I've read about this issue before in federal court. Didn't the federal courts previously rule that companies do not have to pay hourly workers for things like security badge checks at the end of a shift or health screenings at the beginning?
You are remembering correctly. Under the Federal Fair Labor Standards Act, there is a specific statutory exemption for what the law calls preliminary or post-liminary activities. These are activities you perform before or after your principal work duties.
Right.
Federal courts, including the Supreme Court, have generally ruled that waiting in line for a security check or a COVID screen falls under this exemption. It is not considered compensable time under federal law. Amazon's defense team argued this exact point. They said, the federal FLSA says we don't have to pay for this preliminary screening, therefore we are not breaking the law.
But the Illinois Supreme Court looked at the same facts and came to the exact opposite conclusion.
They drew a very sharp, uncompromising line between federal law and state law. The court pointed out that the Illinois minimum wage law simply does not contain the preliminary and post-preliminary exemption found in the federal statute.
Interesting.
Furthermore, they looked at how the Illinois Department of Labor defines the term hours worked. Under Illinois state regulations, hours worked includes all the time that an employee is strictly required to be present on the employer's premises.
So if Amazon dictates, you must stand in this specific line in our lobby for 15 minutes before you are allowed to do your job, Illinois law says you are on their premises, you are required by management to be there, therefore they must pay you for those 15 minutes.
Precisely. The state court explicitly rejected the federal exemption, and it serves as a stark, expensive reminder to national corporations. Achieving compliance with federal wage law is the bare minimum. It is not enough to protect you. You must meticulously comply with the specific, highly nuanced, and often much stricter labor laws of every single individual state where you employ hourly workers.
15 minutes a day of unpaid time doesn't sound like a big deal to an individual. But when you multiply that 15 minutes by thousands of warehouse workers working 5 days a week over several months of a pandemic, you are looking at a back pay liability that could easily stretch into the tens of millions of dollars.
Which leads us to the final, ultimate nightmare scenario for any entrepreneur or business owner.
Oh boy.
What happens when these operational liabilities pile up, the macroeconomy turns against you, the business completely fails, and there simply isn't enough money left in the corporate bank account to make final payroll? Does the corporate veil protect the founders? Or do they have to pay the employees' wages out of their own personal savings?
That is the terror of the corporate veil being pierced. The whole point of forming an LLC or a corporation is so that if the business dies, your personal house and your kids' college fund are safe. And that brings us to the Quality Therapy case, a ruling from the Illinois Appellate Court.
Quality Therapy was a healthcare company providing occupational and speech therapy services. They encountered a perfect storm of business failure. They were hit with a massive federal Medicare billing investigation. They incurred exorbitant legal fees trying to defend themselves, and their profit margins completely evaporated.
Just a disaster.
Eventually, The bank holding their debt panicked, called in their line of credit, and legally froze all of the company's operating funds.
So the business literally could not access its own cash. They couldn't pay their vendors, and tragically, they couldn't pay their staff for their final month of work. The company is forced to shut down. Over 90 former employees are left holding the bag, owed more than $500,000 in unpaid wages.
The Illinois Department of Labor aggressively stepped in to recover that money. But because the company was bankrupt and the accounts were frozen, the state didn't just sue the dissolved corporation. They sued the two founders personally, Francis and John Parise, under the Illinois Wage Payment and Collection Act, the IWPCA.
Wow, suing them personally.
The state argued that because the founders were the top corporate officers and they were the ones who made the day-to-day decisions about who got paid and who didn't, they met the legal definition of an employer under the act. Therefore, the state argued the founders should be held personally, individually liable to pay the $550,000 out of their own pockets.
That is an incredibly brutal scenario. Imagine pouring your life into a business, losing it to a federal investigation and a bank freeze, and then the state government tells you that you have to sell your personal home to cover the final payroll because the bank locked your accounts. Did the appellate court side with the state?
They did not. The appellate court offered a highly robust defense of foundational corporate law protections. The judges carefully analyzed two different interacting sections of the Illinois Wage Act. Section 2 of the Act defines an employer generally, but Section 13 specifically addresses the personal liability of corporate officers and agents.
What does Section 13 say?
Section 13 clearly states that a corporate officer is only personally liable if they knowingly permit the employer to violate the Wage Act.
That phrase, knowingly permit, seems to be the crucial shield.
It is the entire defense. The court reasoned that if every manager, CEO, or founder was automatically strictly held personally liable for unpaid wages, simply because they held a position of decision-making authority, it would lead to legally absurd results.
Right.
It would completely destroy the fundamental purpose and protection of forming a corporate entity in the first place. Nobody would ever start a business if a bank freeze meant personal bankruptcy.
Because the founders of Quality Therapy didn't maliciously steal the payroll money. They didn't intentionally refuse to pay their therapist out of greed. The bank legally froze the account. The founders didn't knowingly permit the underpayment. They were legally and physically incapable of making the payment.
The court ruled they were not personally liable. It established a crucial defensive line in the sand. It protects corporate decision-makers from strict personal financial ruin when a business collapses due to financial realities completely outside of their immediate control.
Let's take a deep breath and try to synthesize this incredible journey we have been on today.
It is a massive amount of terrain to cover, and it touches every aspect of how a modern business operates.
We started by looking at the alluring trap of hyper-efficiency, the intoxicating idea that you can scrape 1,000 phone numbers off the internet, load them into a powerful tool like Go High Level, and blast out ringless voicemails to generate easy real estate leads. But we saw how that exact pursuit of frictionless scale created a $3 million liability for Brittany Gaitan simply because she didn't possess a piece of paper proving prior express written consent.
Yeah, and we saw how that specific legal standard is currently shattering across the country. Courts in Texas and Maryland are actively rejecting the FCC's written requirement, ruling that a simple oral phone conversation is enough. This creates an absolute geographic compliance nightmare for any company trying to run a national marketing campaign.
We explored the invisible silent trackers, the metapixels and Google Analytics that are triggering massive wiretapping class actions. We learned the mechanics of how these pixels work and how companies are currently successfully defending themselves by arguing that a piece of code is a direct participant, not an eavesdropper.
And that the encrypted hash data is simply too complex for an ordinary person to decode.
Right. We also learned that if your servers get hacked, like in the Bojangles case, you might temporarily dodge a lawsuit, but only because the Supreme Court requires your employees to actually suffer identity theft before they are allowed to sue you.
From there, we examined the physical and strategic pivot. We watched businesses flee the Measure ULA taxes in Los Angeles, flooding into the South Bay and driving industrial vacancy down to the low single digits. We explored the rise of hard tech, looking at Varda Space Industries manufacturing microgravity pharmaceuticals inside an old Barbie factory.
And we learned that to survive in that hyper-competitive, sophisticated environment, businesses must abandon the legally toxic strategies of digital spam. Instead, they are utilizing the strategy of inbound visual authority. We discussed how companies like Voxel Micro Video Labs use a 12-hour-a-year podcasting model, leveraging 4K cameras and the vertical slice technique to create premium content without format fatigue.
They draw elite clients into a Trojan horse networking environment built on genuine human trust, rather than annoying them with illegal voicemails.
Finally, we turned our attention inward to the operational minefield of labor law. We watched the Supreme Court grapple with whether local interstate delivery drivers can bypass forced arbitration because the bread they deliver crossed a state line. We saw the chaos of 5 different federal circuits applying entirely different rules on how easy it should be to certify a massive wage class action.
We saw courts protect employers by using specific jurisdiction to slice up nationwide lawsuits against a pizza franchisee.
And we face the stark reality that individual state laws, like those in Illinois, can force a company to pay for a 15-minute COVID screening, even when the federal government says they don't have to. Although we did find one silver lining. Founders might be protected from personal bankruptcy if their corporate bank accounts are frozen by a lender, provided they didn't knowingly withhold the wages.
For you, the listener, the practical application of all this information is profound. Whether you are an entrepreneur designing your next marketing campaign, a middle manager dealing with a mix of remote and local employees, an independent contractor looking for leads, or just a curious consumer wondering how that voicemail got onto your phone without it ringing.
The lesson is very clear.
The line separating innovative business efficiency from ruinous legal liability is thinner than it has ever been in modern history. And more importantly, that line is constantly moving beneath your feet, depending on what federal circuit you happen to be standing in, or what new piece of code you just decided to plug into your website's header.
It's constantly moving.
The businesses that are actually thriving, like those absorbing the Capital flight in the South Bay, are the ones actively opting for total transparency, high-quality human connection, and rigorous proactive compliance, rather than relying on cheap, automated shortcuts.
It is a heavy stack of sources to get through, but it paints an incredibly clear, unvarnished picture of the modern economy. But before we wrap up, I want to leave you, the listener, with one final lingering thought to mull over as you go about your day.
We always have to be looking around the corner at what is coming next.
Today, we talked about human real estate agents deciding to press a button to send automated voicemails. We talked about human warehouse managers setting up physical health screening lines. But look at the trajectory of the technology we just spent an hour discussing. Look at the massive algorithmic power required to decode a metapixel hash. Look at the complex, multi-step automation sequences available in software like Go High Level.
The overarching trend of the technology is rapidly removing the human decision maker from the loop entirely.
That is exactly what keeps me up at night. As AI agents become capable of not just assisting us, but entirely running their own autonomous marketing campaigns. What happens when an AI is told to generate leads? What happens when that algorithm autonomously decides to scrape a list, writes its own script, and executes its own ringless voicemail drop without a human ever pressing that send button?
That's a real possibility.
When an autonomous AI hallucination violates the TCPA by sending 1,000 pre-recorded voices or misclassifies an entire fleet of delivery drones under the FLSA, who goes to jail? Who pays the $3 million fine? Is it the software developer who wrote the base code? Is it the CEO who bought the software license? Or is it the machine itself?
That is going to be the ultimate question of legal liability for the next decade.
We started today by talking about the $3 million mistake of pressing a single button. The real question we have to answer next is what happens when there isn't even a button to press anymore?